Okay, thank you. Yes, Mr. Sokwa.
Yes, my lord.
Yes.
My lord, can I proceed?
Yes, you can.
Okay, very well, my lord. My lord, on behalf of the defendant.
Yes. The matter is for adoption.
Adoption of final addresses.
Of final written addresses. And you are ready?
Yes, my lord, we are ready.
Okay. Mr. Gasse, you're also ready?
I'm also ready, my lord.
Okay. Yes, Mr. Sokwa.
Thank you, my lord.
Yes.
My lord, on behalf of the defendant.
Yes.
We have prepared a final written address.
But is there a motion filed to regularize any?
Yes, but it has been moved and granted.
When?
It was moved on the 17th of January, 2019.
Okay. Okay.
Yes, my lord, and
okay.
granted.
Okay. Yes, I can see.
Yes.
Okay. Yes. So yes, Mr. Sokwan.
Okay, very well, my lord. My lord, the defendant has a final written address.
Yes.
Dated the 7th day of November, 2019.
Okay.
Yes, my lord. But filed on the 8th day of November, 2019.
Okay.
The said final address was deemed properly filed before this court on the 17th day of January, 2019.
2019?
Yes, my lord. 17th January, 2019.
But it was regularized?
Yes, at 2020, my lord. It was regularized 17th January, 2020.
Okay, it's dated 7th of November 2020 and filed on the 8th of November 2019,
Yes.
sorry.
2019. Yes, my lord.
Okay.
Yes.
But was regularized on the 17th of
January 2020, my lord.
Okay. Yes.
Yes, my lord.
Yes.
My lord, we humbly wish to adopt the said final written address
Yes.
as the claimant's argument, final argument.
Claimants?
As the defendant, sorry, my lord, as the defendant's final submission.
Yes.
Yes, in urging this court to dismiss the suit of the claimant.
Yes.
Yes, my lord. My lord, upon receipt of the final address of the claimant,
yes,
the defendant further filed a reply on points of law.
Yes.
The said reply on points of law is dated 23rd day of January, 2020.
Yes.
Yes, but filed on the 24th January 2020, my lord.
Yes.
We also humbly apply to adopt same.
Yes.
As the defendants reply on points of law.
Yes.
My lord, I will not know if we have a few minutes to adumbrate, my lord.
Okay.
Yes.
Yeah. Okay.
Yes, my lord. Okay, just briefly, my lord, even though everything is already in the written address and
Yes.
the matter has dragged on for a while, but in summary, my lord, the claimant sued the defendant upon claiming that his termination was wrongful. In defense to the claims of the defendant, the plaintiff, the defendant raised two issues for determination. One was whether the plaintiff has proved his case to be entitled to the relief sought. And two was whether the defendant has proved his counterclaim to be entitled to the relief sought. My lord, basing my argument on issue one, our case is that the disciplinary action that was taken against the plaintiff was very clear, and it was as provided by the policy manual of the defendant, which is that no staff is allowed to pursue outside interest. And if you must take permission from the organization. And the whole essence of this is to avoid.
But Mr. Sokwa, he said that he had disclosed his interest to the line manager.
Yes, my lord. From the facts of the case, the court will see in our argument that the line manager he's talking about was his line manager in a different program.
Which was seconded to.
Exactly.
Yes, which he was seconded.
You seconded him to that other organization. Is that so?
Yes, my lord.
And
yes.
He said that he disclosed his interest to that line manager.
Yes, my
and
lord.
He said that when disciplinary committee was set up, he mentioned the name of that line manager, which you failed to call in order to corroborate what he had earlier on said.
Yes, my lord. Yes. Very well. Thank you, my lord. My lord, just to follow from where my lord stopped. By the policy manual, it was clear that once you are called for an internal hearing, just like we do in the court, you can come with any witness you want, anybody, to prove your case, because it's a hearing. You are coming to prove your claim.
But he said that he had asked you to give him time to call the line manager, but you refused. You refused him that opportunity.
No, my lord, from the cross-examination, the pleadings filed, and his own testimony, my lord, you see that he was given all opportunity, even up to appeal. He appealed twice on this ground.
But he was saying that the person that signed his termination letter, the same person that sat on appeal, about his termination. The lady that testified as DW1.
Yeah, no, that is
the person. The lady that testified as DW1 is the person that signed his termination letter, the same person that had his appeal when he appealed the decision of the defendant terminating his appointment.
Yes, my lord. My lord, it is an organization. So it is an internal hearing. They don't go outside to look. They set up a body.
Okay, and doesn't that bridge the principle of fair hearing? You are the investigator, you are the judge, you are the Mr. Sokwa.
No. The decision to sack him is not taken by her. She is just the one that signs it. They make a recommendation to the board. The board is not part of the investigation committee. They don't have business investigating. They set up an investigation panel. Then the investigation panel will make a recommendation. And then the board will now approve the action to be taken. In fact, in his case, when the panel recommended that he should be dismissed and he appealed, the board say convert it to suspension.
But
This
okay,
is
but
telling you how-
was DW1 part of the panel?
Yes, that was the initial investigation. Yes, my lord.
DW1 was part of the panel,
Yes, my lord.
and she was also the person that sat, on appeal about.
No, she didn't sit on appeal, my lord.
Okay,
She sit on
okay.
appeal. She didn't sit on appeal.
What role did she play? She
She's the
was
human
asked to
affairs.
review.
Yeah, no, she didn't review anything.
Okay.
She's the human affairs person. So all staff issues go through her. So
Okay.
and she was not the one that signed his termination. She was
Okay,
not the one that signed it, my lord.
Your policy manual.
Yes, my
Your
lord.
policy manual mentioned three things as
Yes,
a
my lord.
misconduct.
Yes, my lord.
The declaration of interest,
Yes, my lord.
dishonesty and fraud, and
Yes.
I think on the last one. Three things were mentioned. That's so.
Yes, in fact, there are more, my lord, but those are the ones that pertain particularly to his case.
And they are number one is dishonesty. Okay.
Yes.
Fraud or dishonesty.
Yes.
Then double employment without permission.
Permission, yes. Then
So-
conflict
so-
of interest.
So the was the claimant as the chair, chairman of the board of directors or what of the Emma Foundation. What was
Yes.
the position of the claimant in Emma Foundation?
He was the chairman of the board of trustees.
And then what does that mean that he was an employee of the Emma Foundation?
No, it means he had double employment.
How is that? How is he having double employment?
My lord, as our evidence showed,
Yes.
what brought about our investigation to even find out that Emma Foundation was being run by the claimant was when we realized
I know that, but does that mean that the claimant was an employee of Emma Foundation, being the chairman of the board of?
He was in charge. He was not only an employee, he was in charge of taking decisions on behalf of the board.
Okay, so he may not be an employee of the Emma Foundation. You can only say that he failed to disclose his interest in Emma Foundation to the defendant. Is that so?
That's one, my lord. But
No,
the investigation. Yes.
You see, I want to be clear about this issue.
Yes, yes, my lord.
Do you want to say that the claimant was an employee of Emma Foundation, being the chairman board of trustees?
Yes, chairman board of trustees. Yes, my lord.
Does that mean that he was an employee of Emma Foundation?
Yeah, well, my lord, being the chairman of the board, the
Yes.
effect is that it's not apart from employment, it's the fact that you are under double employment now. You are
Yes,
running
but no, but you agree with me that the fact that the claimant was the chairman board of trustees of Emma Foundation, that doesn't mean that he was an employee of Emma Foundation. Being the chairman of board of trustees doesn't mean that he was an employee of Emma Foundation.
That is where a conflict of interest comes in.
Conflict of interest is different from being an employee. Somebody may fail to declare his interest in another organization, but he may not be an employee of that other organization.
Okay, yes, my lord, I get the point, but if I'll just explain that particular aspect.
Okay.
Now, during the investigation, I realized that the Emma Foundation was also one of the NGOs that was
benefiting from the defendant,
from a project we're doing, which is the honesty that we try to maintain in our organization. These are things that we should know. If one of our staff has an interest in any way, we should know, because it will throw doubt into what we do in the eyes of the public. And of course, when we investigate, we now realize that yes, these people were chosen. And the same, how were they even chosen? When we got their documents from CAC, we now realize that this claimant was a trustee. Now, what made it worse was that he was not a trustee before he joined our organization.
Okay, there is something that I want to ask.
Yes, ma'am.
On what ground did you terminate the claimant? Was he terminated on the ground of fraud and dishonesty, or his failure to declare his interest, or double employment?
Yeah, his failure to declare his interest. Failure to declare his interest. And pursuing outside interest.
Okay, but not the issue of fraud and dishonesty.
No, the issue is that if you see the termination letter, you will not even see issue of fraud and dishonesty.
Okay.
Yes. Okay. The main thing was that issue, because of course for fraud,
his failure to declare interest.
His interest, okay. Yes.
That was the basis of terminating the claimant.
Yeah. Okay. Yes, based on terminating his employment.
Okay.
Yes, my lord.
Yes.
So he also complained that he requested documents to assist him in his appeal, and he was not given the document. But my lord, we even see that all the documents he attached to his claim were everything in his possession. He had everything he needed for any appeal. And even the exhibits he showed, we showed that the response he got from the company was like, you already have the document. So nobody was witch hunting him. What the company was doing was trying to maintain their integrity. It's an international organization. And after carefully going through, complying with their manual, by subjecting him to investigation, he was free to attend, and he was free to call anybody as his witness. So much so that if he wanted to call his line manager from that project he was seconded to, he was free to call the manager at any time. Nobody would have accused the manager.
He not even asked for I mean, he did not even call him during.
He didn't call him
during the court proceedings.
Yes, he didn't call him, and that can be taken as withholding evidence. Because if you are honest and you know that this man will come and support you and say the truth, you will not have any fear to call him.
Okay, but
to come and the court will summon him.
Okay, there is another issue that the claimant raised.
Yes, my lord.
That the time he was seconded to that other organization,
yes, my lord,
he ceased to be under the defendant organization. In the moment he was seconded to that organization, he would now only be bound by the manual policy of that other organization, not the policy and procedure of the defendant. That's why he didn't disclose it to the defendant, but he disclosed it to the line manager of that organization.
Okay, my lord. My lord,
ENR.
Yes, my lord. My lord, the truth about that is that, first of all, whether he was seconded or not, he was our staff. And at every point, he was bound by our policy manual. Even if temporarily are seconded to anywhere, it does not stop him from complying with because we were still paying him. That's one. Then two, my lord, which is in my written address, this failure to disclose interest is not only because of this project at ENR. Is that the fact that after you joined our organization and you decided that, okay, I want to run an NGO myself, that was the time you should have even told us, not because of what happened when he was seconded with the suspected fraud. It was at the point he was forming the organization. That is what our policy is about. But his did his being a chairman of the board of trustees of Emma Foundation, did that conflict with was any interest in your organization? He's been a chairman. Yes, my lord.
Did it conflict?
Yes, the reason is because the object of that company, as it's before the court, we submitted the CAC document, conflicts with the object of Action Aid.
What are the objects? I mean, objectives of
charitable objects, HIV/AIDS, to tender to the less privileged, and so on. Those are the major things we do. So if our staff wants to also do the same thing under another umbrella, it is already conflict of interest.
Was Emma Foundation, was it incorporated to also do such other things that the
Yes, my lord. Yes.
defendant was doing?
Yes, it was for charitable business in memory of his brother, according to him.
Yes, I know. What I'm trying to ask is whether the objectives of Emma Foundation,
yes,
you understand,
yes,
are similar or identical to the objectives of the defendant.
Yeah, they are. That is why the company was easily chosen to be used by the defendant in carrying out their project in Benin State, because they saw that, okay, this is a company that is of like mind. But at that point,
okay, that's Emma Foundation. Emma Foundation was chosen by the defendant to carry out some other activities.
Yes, without without knowing that their staff is the one running the show there.
Okay.
Until issues arose, and investigation now showed that he actually incorporated that organization after he was employed. That is where the issue starts from, not only when he was seconded.
Okay, then when you converted the termination to 4 months and suspension without pay.
Yes, my lord.
After the 4 months, did you restore the claimant and continue?
No, after his project, when all these things happened, he had only 4 months left for his contract to terminate.
Okay.
That 4 months was just so that in his dismissal letter, it will not be dismissal, it will be maybe resignation or whatever, but it will not be termination, just to give him a good
landing.
A good landing, yeah. So take 4 months suspension and let us end in peace. That was the essence of what the wisdom, the panel said, okay, since your contract is almost ending, we don't need to terminate you. Take 4 months without pay and let us bid each other goodbye.
Okay, so after the 4 months, the contract automatically terminated.
Yes.
Okay.
Yes.
Okay.
Yes.
Okay.
So based on all this, my lord, and it's obvious that my lord already has a total grasp of the case, we just humbly urge my lord to look at the authorities we've cited, which are very clear and which hit the nail on the head on issues like this in organization, and when they take disciplinary actions in line with their policy manual, and dismiss the suit, the claimant, with substantial cost, because we've really suffered in this matter. All the way to Makodi for the years the matter has been on, and I want to thank my lord for carrying the file to Lagos, so we don't have to start all over again. We will have started again.
Thank you.
That's our submission, my lord.
Thank you.
Thank you.
Yes, Mr. Gasse.
Yes. Very well, my lord. My lord, the claimant's final written address.
Claimant's final
written address dated the 13th day of January 2020.
Yes.
And filed on the 17th day of January 2020.
Okay.
Yes. That is claimant's final written address. It was dated the 13th day of January 2020 and filed on the 17th day of January 2020.
Okay. Yes.
Yes, we adapt the final written address and urge the court to enter judgment in favor of the. My lord, I wish to point out some few things raised by my.
Yes.
My lord, the sum total of the claimant's case is that
yes,
he disclosed his interest, conflict of interest was disclosed to the respondent.
How?
My lord, it was disclosed through the line manager, Johnson Ekele. other organization was seconded.
But Mr. Agassi, is that enough disclosure to disclose their interest to the
Yes.
line manager, verbally?
Yes, my lord, that was enough disclosure because the standard operating policy of the
Yes.
respondent has provided a channel of communication such that once an employee of the respondent is seconded to another organization, he has to report whatever challenge or conflict or interest he has. He has to report it to the leader of the other organization, in this case, Johnson Ekele. And so the claimant reported his conflict of interest to Johnson Ekele. It was left for Johnson Ekele to now communicate to the respondent because there was no way the claimant could have jumped.
Okay. Mr. Agassi, when he was seconded, who was paying him salaries?
Yes, the respondent was still paying him salaries.
He was still paying him salaries, yes.
Yes,
Yes.
but the same respondent provided the channel of communication, which has to start from Johnson Ekele. And then Johnson Ekele will now communicate to the parent organization and not for him to jump.
Okay, but was Mr. Enekele was he a staff of the defendant?
Not at all, my lord.
Not at all.
The
Yes.
staff of the other organization to which the parent was seconded to. He was the leader of the other organization to which the second.
Yes, but the moment the fact that the claimant was seconded to an Ekele's organization, does that mean that the employment of the the claimant ceased to be an employee of the the defendant?
No, not at all. He was still employee of the second of the.
And the interest the interest the defendant is trying to talk about, that interest, was it with regards to an Ekele's organization or with regards to the defendant? The conflict of interest.
With regards to the claimant's interest in another organization, the conflict of interest was with regards to the claimant's interest in another organization, Emma Foundation.
Yeah, what I'm trying to say that interest that the defendant is saying that the claimant did not disclose.
Yes.
The interest is the conflict of interest is in the defendant organization or in Mr. Ekele's
only with the respondent, that is the claimant's parent.
The defendant, yes, the defendant.
Yes.
So if that's the case, why should the claimant only disclose that interest to his line manager, not to the defendant directly?
My lord, what I'm saying is that there was already a channel of communication provided in the respondent's policy document that in the event you report to this one, it is this one that will take your report to us.
And it was not communicated formally.
It was because the policy did not state the manner of communication.
Okay.
It did, so oral report was enough.
Okay. Oral communication was enough.
Was enough because the manual, the policy of the respondent did not state the manner of report or communication.
Okay.
Yes.
Okay.
Yes. And also, my lord.
Yes.
The respondents in the respondent reply to our final written address.
Yes.
Yes. The respondents council raised two issues, which even though I do not have a response because it is a final written address, a reply. And he raised issues that are new.
Yes.
Yes. For instance, in paragraph.
Yes, in paragraph.
In paragraph 2.12, 2.12, yes, the respondent council has raised issue of dumping or document.
Dumping, yes, dumping.
Yes. Our contention is that the respondents' counsel was the first to write his final written address. He would have raised this issue in his final written address. So
Okay,
that
okay,
yes,
okay,
he did do that. So I'm urging my Lord
okay,
to countenance this paragraph of
okay,
the reply, and also
okay. To this countenance paragraphs 2.11 and 12
yes,
of the defendant's reply on points of law, because the
yes,
issue, the argument therein
it's a fresh issue he should have
okay,
included in his final.
which we did not raise in our response. Yes. Yes.
And also assuming without considering
Yes.
that, or we also wish to argue that there's no documents,
That
there's
was
no
dumped.
claimant's document on the court. All the documents,
was-
my lord, the meaning of dumping a document is that where a document, there's no evidence relating a particular document to a specific part of a party's case, that document can be said to have been dumped on the court. And it is not the case here. Each and every document we have front-loaded has been mentioned in the statement of oath of the claimant.
Okay.
Yes. Under the front-loading system, the witness statement is the evidence on oath.
Yes.
So each of the documents has been mentioned in our pleadings and in the statement of oath of the claimant. So the document, one of the documents was dumped on the court.
Okay, okay.
And also my lord,
Yes, Mr. Augustine.
also in paragraph 2.4 of the respondent's reply to our final written address.
Yes, yes.
Yes, he's also raising the issue he's raising there is that
Gimba panel.
yes, that our client, that is the claimant, did not raise issue of refusal of the respondent to supply him documents he needed for his appeal. He said we did not make that as our case, and so we are only bringing in our written address.
In our pleadings, that he didn't bring it. He didn't raise that issue in our pleadings. It was only raised in your.
We are saying is totally incorrect.
Okay. Okay.
Yes, our paragraph 7 of our reply,
Yes.
our amended reply to their defense. Paragraph 7.
Yes.
Paragraph 7.
Yes. You've mentioned that issue.
Paragraph, we specifically mentioned that some documents the claimant requested from the respondents to enable him prosecute his appeal were rejected.
Okay. Okay.
Yes, he was refused being given some documents, and so a reply is a pleading.
Okay. Okay.
If matter for decided on pleadings, statement of claim, reply, and statement of defense, these are pleadings.
Yes. Yes.
So we already provided in our reply, paragraph 7 of our reply to his statement of defense, that the claimant was denied certain documents. to file an appeal against his dismissal.
In your paragraph 7 of your reply?
Yes, yes, in paragraph 7 of our reply to defendant's statement of defense, we provided for that. We provided that the the claimant was denied certain documents to prosecute his appeal, to file an appeal.
Okay.
Yes.
Yes.
Yes. And my lord, what's of it? The documents, the person who refused to give the claimant these documents, that is DW1,
Yes.
was the one who was appointed to be the leader of the panel to review the claimant's case.
Does that matter?
It matters, my lord. We are talking of denial of fair hearing.
Okay, okay.
Yes, we are talking of denial of fair hearing here.
Okay.
Yes. So even the fair hearing can be deduced from the panel sitting on a party's case.
Okay, okay.
Yes. So the same refused to hand over these documents to the claimant was the one who was appointed to review his appeal.
Okay.
And the CW1 was the one who even signed the letter terminating the claimant's appointment. And he was then appointed again to review or to sit on an appeal filed by the claimant.
Okay.
Yes, my lord, we submit that there's no way the claimant could have got favorable hearing before that kind of panel.
How?
Hmm?
How? How?
DW1 was the one who signed the letter terminating the claimant's appointment. When the claimant,
but does that matter? She said she was a staff of the defendant.
Yes,
couldn't she have written that letter when she, if she?
Yes, my lord, she could
was
have
instructed by the.
She could have recused herself. Just that my lord can recuse himself from hearing some matters. The DW1 too could have recused herself from sitting on the panel, from being the leader of the panel to review the case, because she was the one who signed the letter of termination. You terminate somebody's appointment.
Oh, okay. She sat for the review of the termination after she had already signed the termination.
Yes, after she signed the termination and the claimant appeal.
Then she now sat
yes,
for the review of the.
Very well, my lord. She was the one who was appointed to be the leader. She did not just sit as a member of the panel. She was the leader, the head of the panel to review.
Okay.
Okay. Yes. So there was no way.
But that review. Okay. So that review.
Yes.
Hello.
Yes.
That review. That review. That. Are you challenging that review?
Yes, we're challenging everything. We are challenging the first panel that terminated the appointment and the second one that reviewed, because both of them did not give our client fair hearing.
Okay. Then with regards to that renewal, okay, not renewal, with regards to that review,
yes.
Does the claimant need any fair hearing with regards to the review?
Yes, my lord, he needs fair hearing.
Okay.
He needs fair hearing. In fact, anywhere the panel is set up for the hearing of a claimant's case, he needs to be heard fairly before any of such panels.
Okay. It's okay.
Yeah.
It's okay.
I also wish to point out something, my lord. In the course of my learned friend's adumbration, he said that the letter of termination did not even mention the word there. I mean, the word fraud there. That is not true. in the letter of termination, it is specifically stated that the claimant has been dismissed for fraud.
Oh, okay. Then what about the letter of suspension? Did it mention anything fraud or dishonesty?
Yes, that is what is.
No,
yes,
I mean
that is
in
what
the letter of suspension. In the suspension, after the letter of termination was given, there was the termination was converted to suspension, 4 months suspension without pay. Then does that letter also say anything fraud or dishonesty?
No, my lord.
Okay. So the termination letter it includes the word fraud.
Yes.
It contains fraud, the word fraud.
Use the word fraud.
Okay.
Termination of appointment for fraud.
Okay. Not termination on non-disclosure.
Well, that is the way they use, because it is the issue there is that of conflict of interest. I don't know how they changed it to fraud.
Yes, because Mr. Sokwa.
Yes, my lord.
I think there is a difference between non-disclosure and fraud and dishonesty. Is that not so?
Yes, my lord.
You may, the fact that somebody has failed to disclose his interest, he may not be found to have committed fraud or dishonesty. Is that right?
Fraud, yes, but dishonesty is if you fail to disclose your interest, is actually a clear case of dishonesty, having known what to do. And I think the fraud came in because of the circumstances in which we found out.
Well, what are circumstances?
The circumstance was that he brought in his personal NGO to benefit from a grant that was given by the defendants for the performance of some duties in Benin State. Now they will benefit monetary gain.
But should that be fraud? Should that be fraud there? The fact that somebody has brought his NGO to benefit from.
Yes, I think the basic thing there is dishonest to gain monetary favor. They dishonest to gain monetary favor, and then they didn't disclose all these facts that these are the people, and then because of that, it caused a lot of controversy to the extent that they now decided to pull out of the project.
You know, the word fraud is so heavy. It's so heavy.
Yes, my lord.
My lord, as against non-disclosure of conflict of interest, or just mere dishonesty. It's okay. It's okay.
Yeah, they all go together, my lord. They all go together.
Okay, it's okay. Yes, Mr. Agassi. Is that all, Mr. Agassi?
Yes, that's all I have, my lord.
Okay.
I urge the Honorable Court to allow the plaintiff's case.
Okay, thank you. Okay, thank you.
We are very grateful, my lord.
Sorry for the delay. I've actually, experienced so many challenges. The issue of COVID, the matter was supposed to be, adopted before COVID. So COVID came. Then after the COVID, the issue of my transfer. Right. Then after the transfer, there was the issue of Jusun strike.
Yes.
And other challenges that I do have with regards to my settlement in Lagos State. Yes.
As a corporation, we quite understand. We
understand that.
Yes. So it's the 7th of January. Okay, sorry, it will be 7th of. Okay, we're in January now.
Yes, my lord.
So next Friday will be. It will be 4th. That 4th of February.
Yes, Friday will be 4th of February.
Is that okay?
For us.
It's okay, my lord.
It's okay.
Yes, sir.
Okay. So matter is adjourned to the 4th of February 2022 at 4:30 p.m. for judgment.
As a copy.
The listing will be sent to you, the link.
As a copy,
As a copy.
To be sent to you. Yes, via Zoom. So, Mr. Agasian Sokwa.
Yes, my lord.
That will be all for today. I wish you a very good evening. I thank you so much.
Thank you, my lord.
Very
Yes.
grateful. We appreciate you.
And I wish you a very nice weekend.
Yes,
Thank you.
we are
Thank you, my
very
lord.
grateful. My Lord
Thank you.
has said this matter.
A lovely weekend to my lord.
Thank you. Bye-bye.
Bye-bye, man.
Okay, thank you.
Couple judgment. Move on and do it now.
Thank you, Chief.
Move on and do it.